let me adjust this real quick. There we go. It is a sizzling Saturday evening here in the great state of Oregon, or at least in the Salem area. So here's proof. This is an app on my phone. "99 degrees. And it's going to be like this for the next few days. Anyway, welcome everyone to a Saturday night edition of Bethea'S Byte Reloaded. Welcome to Saturday night's main event. I'm Ernest Bethea, the last Outlaw. So good to be back with you after a week away, where my wife and I celebrating our wedding anniversary. And we also had a short week due to the 4th of July holiday, but that doesn't mean true crime stories ever stop. So, without further ado, let's get on to business, starting with a previous missing persons case that I'm bringing back to your attention again. Alright, the young lady on the left side of your screen is Ashley Summers. Ashley Summers has been missing between July 7th and July 9th of 2007 out of Cleveland, Ohio. Let me run it down for you. She was born June 16th, 1993 in Cleveland. She has brown hair, blue eyes, and at the time of her disappearance, she stood about 5 feet, 5 inches tall, weighed around 130 pounds. She has a tattoo with the name Jean in black ink over a red heart on her upper right arm, similar to the one that you're going to see right here. Here's your details. Ashley Summers was last seen near a family member's residence in Cleveland on July 7th or 8th, 2007. At the time, she was only 14 years of age. Now, this is where everybody in the Cleveland area comes in. If you have any information on the whereabouts of Ashley Summers, please do not hesitate. You're asked to call 911 or get in contact with the FBI's field office in Cleveland. You can also get in contact with the FBI by using their toll-free tip line. That number is 1-800-CALL-FBI, 1-800-225-5324. If you want to remain anonymous, you can submit your tip that way. The address is tips.fbi.gov. tips.fbi.gov. Your diligence, all the information you can provide will be the difference between bringing Ashley home safe and sound. You're asked to share this information with someone who may have valuable information that could bring her home. And as always, remember, if you see something, say something. That way, we can do something. Alright? Let's do everything we can, and let's bring Ashley Summers back home safe and sound. Alright. So, I've been away for a week. But like I said, that doesn't stop true crime stories from going down. Here's proof. We start with breaking news from early in the week. Now, for a lot of you, you may have sat through days upon days and weeks upon weeks of testimony in the case of the Commonwealth of Massachusetts versus Karen Reed. Then you spent the last few extra days after that for jury deliberations. Now, this is the portion you get. I'm going to jump out the way, and I'm going to let you see and hear this for yourself.
Please rise for the jury. Court is in session. Please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please.
That's right, you heard it here. The judge has declared a mistrial because the jury cannot come back with a unanimous verdict one way or the other. So what does that mean? That means that prosecutors will have the opportunity to do this all over again. Let me write it down for you. Mistrial has been declared in a high-profile trial of a Massachusetts woman accused of killing her police officer boyfriend. Karen Reed stood trial for the death of Boston police officer John O'Keefe, who was found dead in the snow outside the home of a fellow officer in January 2022. Prosecutors accused Reed of hitting O'Keefe with her car while dropping him off at a party at the residence and leaving him to die. Her attorneys alleged a sloppy investigation and a cover-up. After 5 days of deliberations, the judge declared a mistrial after the jury insisted they couldn't reach a unanimous verdict. A status conference is scheduled for July 22nd. Reed is charged with second-degree murder, motor vehicle manslaughter, while driving under the influence, and leaving the scene of a collision causing injury or death. She is facing life in prison if convicted at trial. Reed's case has captured attention across the globe with allegations of a police cover-up orchestrated by parties with significant relationships, alleged romantic entanglements involving Reed and O'Keefe, and a blogger vocal in their defense for Reed facing charges. Protesters have also taken center stage in their fight against the buffer zone, accusing the prosecution of going on an unchecked bender. Following the mistrial, the Massachusetts State Police announced that Trooper Michael Proctor had been relieved of duty. The department said this follows our previous decision to open an internal affairs investigation after information about serious misconduct emerged in testimony at the trial. The investigation is ongoing. So, Karen Reed can look forward to sitting for another trial. Hopefully, the prosecution can get it right this time, because if there's anybody who believes that this case was bungled, it's Court TV's own Julie Grant. In this short week, she had opening statements, including this one, where, like she said, the prosecution bungled this case. So what I'm going to do, normally I would save her opening statements for the end of this broadcast. I am going to set this up right now for her opening statement on this case. So let me take a page out of her book. If you haven't had a bite to eat yet, and grab a bite to eat, grab a bite to drink, settle down, because it's now time for Julie's opening statement on this case.
What a bungled mess. 9 weeks of testimony, 74 witnesses called, 675 case exhibits, all that hard work, and they're going to have to do it all over again. This case was bungled from the very beginning. Why were the charges increased from manslaughter to murder? Was that really necessary? Or did it just confuse the jury? Someone intoxicated, enraged, and throwing their big SUV in reverse in a snowstorm after a person who just got out was behind them sounds more reckless than it does murderous. When the defense team started criticizing the law enforcement involved and making accusations of a cover-up, why wasn't the case turned over to the Attorney General's office immediately for an independent agency to vet the case and do the prosecution? When the defense team started trying their case on the courthouse steps, why wasn't a gag order imposed on the parties? When the demonstrators needed to be kept a certain distance away from the courthouse so as not to influence the jury, why didn't anybody say, this jury ought to be sequestered too? The prosecution's case was confusing. The order of the witnesses made no sense. It was far too focused on rebutting the defense narrative that was told outside of the courthouse. And the defense bungled things a bit too, promising to present a third-party culprit defense involving 3 parties, and that never happened during the trial. I could go on and on about the ways in which this case was bungled. And the people I feel the most sorry for are the O'Keefes. The trial over the death of their loved one turned into a circus. That was a debacle in Dedham, is what it was. Let's hope everybody does things better next time. Let's hope the same mistakes aren't repeated. No matter what side you're on in this case, or what you believe, one thing remains true in all of this, that Officer John O'Keefe is a victim who deserves justice.
Absolutely. One, I agree with Julie that the case was bungled from day one. 2, I agree with Julie that there is one victim in that case, and that was Officer John O'Keefe. And 3, I do hope that both sides, the prosecution and the defense, do a better job of displaying this case next time, because believe me, there will be a next time. And hopefully when that next time does roll around, it will result in a unanimous, clear, and concise verdict. After all, like Julie said, John O'Keefe deserves justice, and hopefully justice will be served when that trial goes down again. And by the way, anybody wants to know why I stand with Julie in a lot of the cases she covers, it's because she's been on one side of that courtroom as a prosecutor. She's been in the classroom teaching college students about the law. And one thing that both she and I can agree on was that from what I have seen and what she's witnessed, that case was a circus from Jump Street. And the jury was deadlocked from the beginning. So what I'm going to do is let her unleash on one more thing regarding the Karen Reed trial and the additional trauma that's being compounded with the circus that is the trial. So let's just kick back and be prepared for another opening statement.
Statement. Real people, real crimes, real trauma. That's what true crime cases are all about. Real people who've experienced horrific things. Real people who suffer traumatization again and again and again as a result of being victimized by somebody else. I fully appreciate that the criminal mind can be fascinating. It can be perplexing, and that some criminal cases can be mysterious and compelling. But the one thing I can't impress enough upon anyone drawn to watching true crime cases is to always remember the people who are impacted. The example I'll use today is the case that has us on a verdict watch in Massachusetts. Through the trial, the members of the O'Keefe family are having to relive the trauma of losing their Johnny. There will either be a verdict or a mistrial, and that will bring the last several weeks to a halt. But for the O'Keefe family, the pain continues. We're already broadcasting other trials. But for the people victimized in this case, they're going to continue coping and healing from the death of their Johnny every single day thereafter. For many of these case witnesses, they are victims in another pending criminal case. They're going to be giving testimony about the torture and the harassment that they've suffered because of their willingness to testify against Karen Reed in her trial. The two cases are inextricably linked. Cases they are, but the people who are part of them are just like you and me. Real people who feel heartbreak, real people who feel mental anguish. So whenever you think about a criminal case, keep in mind how the people actually affected are badly hurting, while the rest of us are watching what is to us just another trial.
And that's the reason why I got into true crime in the first place. On the outside, it may be just another case, just another trial. But when you really look at it at the big picture, there are people involved, real people. And so I try to look at this from both lenses. One, where we're always seeking justice, but but remember, we're seeking justice for the victims and their families. We're seeking justice, but we want to give those families peace of mind that the person that hurt them, the person that took a family member from them, will get the due justice that they deserve to get, the due punishment. Which is another reason why I said before that I'm hoping and I'm praying that both prosecution and defense work harder, work smarter to present this case a lot better than what they did that earned both sides this mistrial. And that's all I got to say about the Karen Reed case. Let's move right along. We got some sad news earlier this week. That involves our Georgia firefighters stand by, and I'm gonna let you get a the
Now for what's trending in true crime, the search for two missing Georgia firefighters has come to a tragic end. The bodies of Reagan Anderson and Chandler Kubander were recovered in Tennessee on Sunday. The two were last seen in Georgia almost a week ago. And Chandler's mom spoke to us here on Opening Statements on Friday. She told us about Reagan's toxic reaction to Chandler going out on a date.
And she found his car and where they were at and came and keyed his car while he was on the date, and he called the police. She subsequently went to jail and bonded out on her own, but during that time she was calling and texting my son because she's terrified for her to lose her job. They are great firefighters. This is just, she's not in the right headspace at all.
Now, we reached back out to Jane Kubander after hearing about Chandler's death. And although she says she's not ready to speak, she hopes that her son's death draws attention to the stigma of abuse on men, referring to emotional abuse. Our question this morning, the biggest red flags in the case of Kubander. Let's bring in our guests. Joining me now, retired FBI Special Agent Jennifer Coffindaffer, criminal defense attorney and former prosecutor Franz Borchardt, and retired criminal defense attorney Kirk Nurmi. Great to see you all. We heard about the toxicity, the red flags. Mom Jane knew it all. She had the bad feeling, and sadly, she was right. As we look at this case and looking at it objectively, I want to ask each of you the things you saw as the biggest red flags here. Agent Coffindaffer, would you start us off, please?
Yeah, absolutely, Julie. Thank you for having me. First of all, anytime when you have a relationship that begins with threatening, threats and instability and verbal assaults and accusations, the things that we've been hearing about that occurred in this relationship, and then you have it followed up with something physical such as that key strike against the car. That's when things start getting elevated, and that person is willing to take a physical offense toward the person that they're angry at. So to me, that was the biggest indication of serious trouble afoot.
Yes. Kirk Nurmi, to you next, please. A lot of people wondering if we're going to see results from this investigation indicating a murder-suicide. Your thoughts on that possibility, please.
Well, that's certainly possible given what we've heard. Like Jennifer mentioned, the acts of violence is that crossing of the line that someone is willing to break the law. I think we see a lot of these people, when we talk about red flags, their identity becomes so consumed by the relationship that they fear the end of the relationship is really going to be the the end of who they are. So that's certainly a possibility that needs to be explored. And I don't want to speculate at this point in time, but at the same time, yes, that crossing the line into violence, it makes it seem like that's certainly a very good possibility, Julie.
Right. Kirk, thank you for that. Last but certainly not least, Franz Borghardt, want to go to you on this. What are you thinking about this morning as we get into this investigation?
What I'm thinking about is how preventable this is, right? And it's becoming more and more normal, Julie, and that's the scary part, right? It's becoming more, you know, we're seeing headlines of toxic relationship leads in this, and it shouldn't be normal. It's very preventable, and maybe if there's any kind of value in what's happened to these two individuals is we can all have a little bit deeper conversation with those we care about that are in toxic relationships to say, hey, look, you know, there is a way out. You can get out. It doesn't have to end this way. And this is what is sadly happening around the country right now.
Mm-hmm. Yeah, you're absolutely right, Franz. Great point. Before we end this discussion, if you or someone you know is in crisis, please call or text 988 to reach the Suicide and Crisis Lifeline.
I'm gonna stand with Julie on that. As far as her the last statement in that interview, there is help. I don't care if you're male, female, if you're in crisis, there is help on the other side. Please, before you think about doing anything drastic, get on with the Suicide and Crisis Lifeline. That number is 988. 988. And if you really want to take this to another level, get on the call the Substance Abuse and Mental Health Helpline. That number is 1-800-622-HELP. 1-800-622-4357. And if you need to take this thing even further, you're always free to call the National Domestic Violence Hotline. You do not have to be a statistic. That number is 1-800-799-SAFE. 1-800-799-7233. All three of those numbers are on 24 hours a day, 7 days a week, and they are available in over 150 languages. They are here to help you out. You don't have to be a statistic. You don't have to be a victim per se. Help is there. It's just a phone call away. And as for the families of both Chandler Kubander and Reagan Anderson, I hope that they'll find peace after their tragic loved ones sudden passing. Moving right along from a tragic case to a case that one hasn't even reached court yet, but two has me laughing my tail off. What the lady you're looking at on your screen right now is Susan Boone. Friends, this is the person. Let me take off that National Domestic Hotline number off. If you got it already. Okay, there we go. This is what you look like when you have ran through not one, not two, 3, 4, 5, 6, 7 attorneys, 8. You ran through 8 attorneys, and the judge said, like the old TV show, 8 is enough. Let's go to the judge to see exactly what's in store for Sarah Boone.
Welcome back to Court TV Live. We are switching gears now to Florida, where defendant Sarah Boone is now going to be representing herself at trial. There was a last-minute hearing on Friday, and the judge in that case said 8 is enough, granting Boone's former attorney's motion to withdraw and ruling that the defendant has now, on her 8th lost attorney, forfeited her right to counsel because of her ongoing difficulties with all of those other counsel. At a status conference last month, we heard Boone express her frustrations and telling the court why she thinks that things could be going better, saying, quote, she was doing her best.
And I feel that she is untruthful with me and full-blown prejudice against me, which I believe adds to her nasty attitude towards me, and I do not trust her. So I have prepared this for you. It's a letter and then a continuation of the letter from the video visit, sir, you are aware of, and everyone constantly blames me that I am the reason why I am supposedly on attorney number 8, which I am not the reason for any of them. I put this in here also so you are aware. I refuse to be mistreated by her as my attorney. I'm shocked that she has a proposed trial date, considering the fact that I have not seen anything. I keep asking her for just a download of my phone or my medical records or for anything that I've asked pretty much all of the other attorneys as well. All of my questions that I keep asking her are in a letter to you. I didn't know if you would be the one to help me answer them or to spur her to finally answer them to me and hopefully truthfully. I don't know. As I've said to you before in the past, you said that you are not able to intervene regarding my letters. I still want you to be aware of what it is that I am going through still. And it's a matter of ethics and professionalism with how she should be treated, and I shouldn't have to come up with a pre-pinned judge in order for her to do so. And also some other things that I've been working on in the meantime that I would like everyone else to be made aware of. That I don't just sit and eat bonbons and watch soap operas all day. I fully apply myself at all times.
The court knows I've spent probably 20 hours, a little bit more, a little bit less, with Miss Boone. She has lots of lists, lots of questions. In reviewing the court file, she was distressed previously about having access to her lawyers. I have taken collect phone calls from her that are at my expense. JAC doesn't reimburse you because I think it's important for clients to have access. I have spent...
Hang on, please. No one's interrupted you this morning, Ms. Boone.
As I said, I've spent over 20 hours going through her questions, going through her lists. When I tried to update her with regard to the depositions that I took recently, she opted to exit the jail conference. When I tried to review some things with regard to discovery as to things I wanted to make sure she was aware of, she walked out. She has asked me repeatedly for a copy of some medical records. Based on the discovery I got from the previous attorneys, one of the copies of those medical records had her handwritten notes. So she had a copy given to her previously. She reviewed them with previous attorneys. I sent her a new copy. Some of the things that she thinks are important from a lawyer perspective, perhaps I don't attach the same importance to, And you try to explain that to a client. I know the court's in a difficult position, but at this point, we're at that impasse of if she walks out of every conference that I give with her, I'm not sure what that says about the attorney-client relationship.
I don't know what I'm doing wrong other than wanting to have a very successful outcome. It's just been long and drawn out, and I believe that God obviously believes in me as much as I do him in order for him to give me this very unique adventure that I am on, and I'm doing my best to let everyone know who I really am as opposed to the malicious murderer that everyone thinks that I am. I don't feel that she can do that properly. I still always, the reason why I'm here is hope that she will come in with a gentle, softer side and actually listen to what it is I'm saying and see the bigger picture other than what's the one avenue that she keeps going down. There's other ways to win and more than one way. I'm not sure what I'm supposed to do, but I'm not saying that I'm trying to remove her. I'm just trying to ask you, please, forgive me for having to ask you for this. If you could please let her know, please, to just be nice to me.
The defendant there calling this a, quote, unique adventure that she's on. Her trial is set to begin on October 7th, where she's going to face charges in the murder of her boyfriend, Jorge Torres. She admits to zipping him up in a suitcase and maintains that his death was an accident after a night of drinking. Still with us, criminal defense attorney Marie Pereira and criminal defense attorney Josh Schiffer. Marie Pereira, based on what you just saw from her inside of the courthouse, thinking back to the pro se defendants that we've had on court TV, what do you expect from this defendant? Do you think we're going to have a lot of antics in the courtroom, something more like Darrell Brooks, or something that might actually sway a jury like in the Tyrone Tucker Treehouse murder trial?
She seems very articulate and reasonable, but she is kidding right now. She wants a gentle, softer side in her defense attorney. That coming from someone who allegedly watched her boyfriend suffocate in a suitcase while she says, you can't breathe? Maybe you need to shut the bleep up. Really a gentle, softer side. That's hilarious. If it wasn't so tragic, it would be hilarious. But she seems very well thought out. It seems like she wants to be wannabe lawyer, and she's telling the woman maybe strategy that makes no sense. I had a client once who abused his daughters sexually and wanted me to lodge a defense that they were promiscuous, and he thought by abusing them, it would calm down their sexual urges. A church man, by the way. This is, people... Defendants sometimes think that they can tell you these absurd defenses and you're supposed to just take it. And I think that's what's happening here with her lawyer. It's just tragic, but I don't think she's going to be Darrell Brooks, and I don't think there are going to be antics. And it might even make it worse because she sounds like someone who makes sense, except you don't make any sense right now, sis, at all.
And Josh Schiffer, I know you've said that you don't think she's quite competent, just barely enough to stand trial. Do you think that the judge should or will give her standby counsel, so someone who's not her immediate attorney but will at least be there at the chair if she needs to consult someone?
I think there's definitely going to be some sort of remedy applied by the judge to protect the integrity of the prosecution. What we've seen is a person refuse to basically work with all of the lawyers. And it's not just been one or two. This has been a revolving door. And at some point that is obstreperous, it is wasteful, and the judge has to put a stop to it, which they've done. Forfeiting your right to counsel is an extraordinary remedy. Remember, you get a right to counsel in the Constitution. So this is a giant issue. I think she's going to rely, just like Marie's talking about, on almost the pity factor.
Josh Schiffer, Marie Pereira, thank you for everything.
Now, I'll agree with this. If this case wasn't so tragic, it would be absolutely hilarious. Absolutely hilarious. Because this defendant has gone through 8 different attorneys, people trying to help her. put together the best defense possible. Now, mind you, you saw the graphic from Court TV. She's facing second-degree murder charges, and her original defense is that it happened because they were drinking and played a game of hide and seek gone bad. So, like I'm saying, she's ran through 8 attorneys that were trying to help her out. And apparently neither one of those attorneys were to her satisfaction. So the judge says, okay, you feel they're not doing right by you? Here's what you can do. You, defendant Sarah Boone, DIY. Do it yourself. Now, on the one side, I can agree with the judge because of the fact that, again, 8 attorneys and none of them were to your satisfaction. Then we go to the point of the judge tells her that she's gonna have to represent herself in court. There is a saying, folks. He or she who represent themselves in court has a fool for a client. Sarah Boone, meet your client. Keep this in mind. Again, I mentioned a second-degree murder charge. She faces a potential sentence of life in prison if she's found guilty of killing her boyfriend Jorge Torres, found zipped inside of a suitcase in February 2020. Boone admitted to zipping Torres in the bag, but she maintained the death was an accident resulting of a game of hide and seek gone wrong. Good luck, Sarah Boone. You're really gonna need it, because a defendant's record defending themselves in court is what I like to call oh and forever. Outlaw, what does that mean, oh and forever? Meaning there has been no criminal defendant who has represented themselves in court been able to escape a guilty verdict. None. Sarah Boone believes she's the first. Good luck. But let me remind you of the previous one, and I plan on covering it before the summer is out. Coming soon to Bethea'S Byte throwback, the state of Wisconsin versus Darrell Brooks, the Waukesha Christmas Parade attack. Remember that? Brooks defended himself. Brooks interrupted the judge more times than I can count. And in the end, the man was found guilty. I don't mean to spoil it for you. I didn't mean to spoil that for y'all. You're gonna have to see the whole thing in when I do a Bethea'S Byte throwback on this case. But I'm telling you flat out, he defended himself. He didn't have an attorney. He decided with his sovereign citizen self that he was going to defend himself against all those charges. He failed at that. He failed miserably. If you want to find out how bad, I will let you know when I'm gonna go ahead and unleash Wisconsin versus Brooks. Bethea'S Byte Reloaded throwback. In the meantime, again I say with every bit of my heart, Sarah Boone, good luck, because you are going to need it. Next up, judge released the transcripts of the 2006 Jeffrey Epstein grand jury investigation. Oh boy. Prosecutors knew Epstein raped teen girls years before the deal? Oh, B-O-Y. Let's go to Court TV's Michael Ayala for more on this, because even this has rocked me, and no, this has nothing to do with politics.
Switching gears now to a story that we've been following for a while here at Court TV, the case against the late Jeffrey Epstein. Now, newly released documents from a 2006 grand jury investigation suggest Florida prosecutors knew that the late millionaire and financier sexually assaulted teenage girls 2 years before they cut a plea deal. Now, that plea deal has long been criticized as too lenient and a missed opportunity to imprison Epstein a decade earlier. Well, the 2006 grand jury investigation was the first of many by law enforcement over the past 2 decades into Epstein's rape and sex trafficking of teenagers, and how his ties to the rich and powerful seem to have allowed him to avoid prison or serious jail terms for over a decade. Scripps News Palm Beach has more on the story.
Within the depth of 200 pages, there's page 129. The last time I went there, he engaged in intercourse. How old were you then? It was the day before my 18th birthday.
How many children they could have saved if they just would have done the right thing.
Brad Edwards represented more than 250 Jeffrey Epstein victims.
I wouldn't want to be the state attorney's office.
He argues this testimony of raping a 17-year-old girl within these documents should have created more severe charges.
But these are people who now have to live with a life of embarrassment for carrying water for Jeffrey Epstein.
Back then, Epstein just pled guilty to 2 prostitution charges. He served 13 months in jail before receiving a work release. In a statement, State Attorney for Palm Beach County, David Ehrenberg, says, "Today is my first time seeing these documents," saying it never possessed them or had access to them. He also said this case occurred before he took office. Worth noting, 2 members of the state attorney's office brought the evidence to the grand jury. Those attorneys accuse a 16-year-old girl of lying about her $250,000 income and age on her MySpace page. The prosecutor also asked if she was aware she was committing a crime by taking money for sexual favors.
That sets a real tone for, and shows what the state attorney's office was really trying to get across.
The jury would ask victims similar questions, asking if they knew they were committing a crime or if they were aware what they were doing to their reputation. In one instance, a juror asked a victim why she didn't ask Epstein to stop having sex with her.
It was designed to get a certain result, and a certain result was achieved. Why they did that, I have no idea.
The grand jury testimony ended with the chief investigator for the state attorney's office going through various police reports about the victims involving alcohol, drugs, and missing person reports.
All right, joining me still to discuss criminal defense and personal injury attorney Samantha Vacchiana and criminal defense attorney, former prosecutor Marie Pereira. Marie, I'll start with you. This one angers me. Mostly because it really highlights the idea, and we've talked about this before, there's 2 systems here. There's one for poor folks, and then there's one for rich folks. And this is a perfect example. Prosecutors can go to the grand jury. It's a secret process. And what you hear from some of those grand jury minutes is basically the imbalance of power and how really what I consider to be witness intimidation. You know, the way that they question them, the things that they were questioning them about, the fact that they never went after him for having sex with underage girls. All these things are just infuriating. And again, as said in that piece, could have saved so many young girls from this type of abuse.
It's infuriating and both shocking because at the end of the day, you know the grand jury presentation is run really by the prosecutors. So why the prosecutors would want to ask questions of the victims that put a chilling effect on their testimony or their willingness to go forward, and that really impact the grand jurors also is shocking to me because you're supposed to be on the side of the victims. So obviously, this guy had connections in the DA's office because why else would they try to ruin their own grand jury presentation? I don't get it.
Well, I get it because you said it, because there were connections. This is how the system works. You know, Samantha, you know, DA is an elected office, right? You got a guy who's got all the money in the world. He calls your office and says, look, you know, I know re-election's coming up soon, you know, love the job you're doing. Keep up the good work. I mean, it doesn't take really much more than that.
Well, I don't know if I'd go that far. I don't think that may be the case here. But, you know, unfortunately, we have certain biases in life. Like you said, Michael, there's one system for the rich and one system for the poor. And if you're rich and articulate and well put together, people tend to, and prosecutors are people, tend to gravitate towards you more, believe you more, want to defend you more, versus if we see someone that, you know, is kind of like looking a little bit, you know, raggedy and not meeting the standards of what we think is a believable person. So I think that's more that than outright trying to be duplicitous or anything to that of that nature.
Samantha, I have to disagree, and Marie, I'll tell you why. Yes, if one person comes forward, you question that person, you try to figure out what's going on. But when you have a series of people coming forward with pretty much the same story, and you have testimony that someone had sex with an underage girl, this is what they're saying, you're taking this case to the grand jury, I cannot believe that prosecutors were clearly going for an indictment or seeking an indictment on having sex with underage girls, because we both know the old saying is, you can indict a ham sandwich. You can do whatever you want in that grand jury room. You can show the evidence you want. It's uncontroverted. There are no defense attorneys there. It's just you presenting evidence to a grand jury. That's the way it's designed. That's the beginning of the process. Defense attorneys join in a little bit later. Your thoughts?
Yeah, I agree with that. Yeah, I agree with that. I'm sorry, Marie. Go ahead.
Samantha, I'll give you a shot right after this. Go ahead, Marie.
Sorry.
I'm just happy that Dave Ehrenberg, our beloved guest legal analyst, was not in charge of that office at the time, because I believe that they need to be investigated. Who presented that case to the grand jury and then tried to chill the effect of the witnesses? I think that person who presented the case needs to be investigated.
I agree. I want charges in this case. That's how outraged I am. Samantha, quickly, I got 30 seconds here.
No, I agree with that. I definitely agree, Michael, that had this been someone who was of less means than Jeffrey Epstein, probably the outcome would have been different. I completely agree with that.
Yeah, no doubt about it.
And this thing with this whole Jeffrey Epstein case has got more knots than I've seen on a rope. I mean, how is it that prosecutors already knew this and didn't get on Epstein sooner? That's the big question I have. It should that plus a deal that he was offered. Of course, they said that the deal was too lenient, and they missed an opportunity to imprison him a decade earlier. The 2006 grand jury investigation was the first of many by law enforcement over the last 2 decades into Epstein's rape and sex trafficking of teenagers, and how his ties for the rich and powerful seem to have allowed him to avoid prison or a serious jail term for over a decade. Now, all I can say is they really should have got him a while back. They should have got him and taken care of business sooner than what they did. Now Now the investigation is who else was involved. Who else was in Epstein's circle doing the same doggone thing. I'm not trying to make this political, but Epstein is linked to 2 former presidents. I'm just saying. Next up, justice served. Alright, on the left side of this YouTube screen is James Brenner. On the right, Dylan Rounds. And James Brenner was sentenced on Monday in Box Elder County, Utah, after he pled guilty to murdering 19-year-old Dylan Rounds. So I am going to step out the way once again, and you're going to hear the sentence for this this convicted murderer.
Turning now to Utah, where the man convicted of killing a 19-year-old farmer learned his fate today. James Brenner had reportedly been squatting on a remote property near Rounds' farm at the time of his disappearance in 2022. That's Dylan Rounds, the victim in this case. He was arrested after a pair of boots were found near the property that contained Rounds' blood and Brenner's DNA. Now, additionally, during the investigation, officials found a time-lapse video showing Brenner cleaning a gun with bloodstains on his arms and his shirt. Now, the shirt in the video was later seized and tested positively for Rounds' DNA. Scripps News Salt Lake City brings us a quick recap on the case.
In that case, as to count 1 murder, a second-degree felony to that charge. How do you plead? Guilty.
James Brenner's guilty plea is part of a plea agreement where he revealed the location of Dylan's remains.
And forensic analysis revealed bullet holes to Dylan's skull, which was the result of defendant shooting him in the head.
Is that what happened in this case? Yes, sir.
Candace Cooley says her son moved to Lucin to pursue his dreams of being a farmer.
He would sit in his underwear out our big bay window and wait for his dad or grandpa to pick him up at 2 years old after he ate his oatmeal to go farm. Yeah, he was a good kid.
Since his disappearance, the family has relied heavily on community support and help from the Missing in America network.
It gets to us personally in a sense that we just want to help. We want to fix the problem. And so it's important that we have this strength together to help everyone.
Brenner's first-degree aggravated murder charge was dropped to second-degree murder because of the plea deal. He also pleaded guilty to 2 firearm felonies. He's looking at 3 to 30 years in prison.
And today, Brenner was sentenced to 1 to 15 years in prison for each of the 3 charges that he pled guilty to.
The one thing I will say is I will ask Mr. Brenner, if you would, I would like you to stand and I would like you to face them, if you would do that.
Like that in your honor, I'd like to know what you mean.
Yes, the gallery.
Is that an order or is that a request?
It's a request. I'm asking if Mr. Brenner will do that.
I have plans to respectfully, but I'll stand.
All right. Mr. Brenner, some of the things that were disturbing to me was that the family was looking for Dylan. You would come around, you would smile and talk with them, knowing full well what had happened, knowing full well what you had done, knowing full well where his body lay, and acted as if nothing happened. My request for you to turn and look at the gallery is similar to something like that. A simple decency. I think the three words that I heard through the letters came through with what was described here. Builder, dreamer, visionary. I don't believe you are those in any respect, Mr. Brenner. That's unfortunate. I wish I could do something more. I understand when this plea was offered and was taken, it was with the consent of the family in an effort to bring closure. So there is nothing more that I can do other than what has been agreed upon. Based on the 3 second-degree felonies, it will be the order of the court to be served 1 to 15 years on each one of those. Those are running consecutive. I will give you credit for the time you served only on those 2 cases, 171 and 110. No other cases. This is in accordance with the agreement, and I want to respect the family with that, and so I'm following that agreement. But I am going to recommend to the parole board that they keep you as long as they legally can. And that's my recommendation to the parole board. I think that's the only leeway I have in the sentencing to offer the family. And with that, that will be the sentence.
All right, so a total of 30 years before he'll be eligible for parole. Brenner actually declined to speak during today's sentencing. Here's what the victim's father had to say in his victim impact statement.
I didn't write any speech or anything. I didn't really even know what I was going to say until I got here. I mainly wanted to talk to Jim. And when this all started, when you got arrested, I asked the FBI agent kind of if he knew anything about your past, be able to see it. But I guess I was trying to figure out a way to forgive it. And then we went to where you laid Dylan, where you tried to bury him. And I asked the same FBI agent if you showed any remorse. And he said you showed no remorse whatsoever that he could see. And he just tried to blame everything on circumstances, whatever. Like I said, I didn't write anything wrong. I just want you to know what you took away. Not just from me, or his mom, or his brother, and sister. You took away someone who was willing to be active in society and contribute to society. As far as I can tell, in your whole entire life, you never contributed to society once. Dylan helped you out so many times, whether it be hauling sugar beets or potatoes or whatever, and this is how you repay him. I just basically hope that you, for the rest of your life, will think about this. And if a 3 to 30 year comes about and you get out, it'd probably be the worst thing that ever happened to you, Jim. And in that time, this is hard. I just hope the rest of your life you remember what you did and what you did, and I hope someday you feel some remorse or some guilt. That's basically all I have to say. And I wasn't going to let you just come in here and limp like a little gimp and walk out with nobody saying anything to you at all. You don't have to look at anybody in the eye or even look at anybody, but turn around and look at the people who you've affected. That's all I have to say. Thank you.
All right, let's bring back in our guest, still with us, Deputy Public Defender for Los Angeles County, Philip Dubé. Philip, first I just want to touch on the fact that, this is a case where a plea deal was done. And I must say, when we talk about plea deals, and I look at the amount of years this guy got for the crime that he committed and the fact that he hid it for so long, hid the body, couldn't give the family closure, I don't necessarily have a problem. He's 60 years old, so 30 years is basically a life sentence for this guy. And also, if you're going to use a plea, this is a great way to do it, because even though it's not a lot of years, this plea allowed this family to get their loved one and the remains of their loved one back, know where that person was. I think it was worth it. Your thoughts on the plea in this case?
Yeah, I think it was a fair outcome, frankly. He was lucky, actually. And the reason why is, imagine if he would have done this at age 25, facing an indeterminate sentence. He would have spent decades longer than 30 years in prison. First of all, his life expectancy would be greater. But the other thing that he did too is he spared the family the agony of having to go through the trial, hear all the gruesome details of how their son died. It was actually the right outcome. Justice was served. And I got to tell you, Michael, I have an issue with proportional justice across this country. Listen, this is a homicide. Even as a public defender, I have no problem people going to prison doing their time. The real question is, what is proportional justice? How much time should it be? I think a message can be sent to a 61-year-old that you're not getting out at least until you're age 91, and whatever life is left for him is not going to be quality life. I think justice was served under the circumstances.
Yeah, fair enough. And I agree as well. I think those things, that the age of the individual should absolutely be taken into account. But here's one thing I do have an issue with here, Philip. When you take a plea deal, as you know, during that plea deal, you waive your right to appeals, et cetera, et cetera. There was no reason why this man could not have spoken in court and said something to the family, to the court, just showing a little remorse. I would have even tried to require it under the circumstances, but it wasn't, and he chose not to speak. What's your interpretation of that?
There are many reasons why our clients choose not to speak. First and foremost, many of them are inarticulate. Many of them are just so inarticulate, uneducated, unschooled. They don't even know how to formulate a cogent sentence and come off believable and sympathetic. And if you have those types of speaking patterns, the victims and the representatives of the victims might take it as being insincere, and it can come off quite offensive. I think the fact that he has taken responsibility, avoided the trial, led the family to that son's remains speaks volumes about his character. And I don't think the family really wanted to hear anything he had to say anyway. I think it would have rang hollow.
At the end of the day, these cases, it's about justice, it's about bringing justice and closure to the family. As I said earlier, I think it's fair to say that the outcome of this case absolutely provides that for the family. And going back to your point about proportional justice, you can't focus too much on the years in a case like this, because again, I believe it was a just outcome.
Oh, yeah, I do too. In fact, I don't think it could have gotten any better, because let's just pretend that he rejected the plea deal, put the family through the trial, he's convicted, and now you're going to have years and years of appeals before the conviction is either affirmed or reversed. Imagine errors being made at the trial level, and 10 years from now, the whole matter is reversed on a federal habeas petition, and having to relive the whole nightmare 10 years from now, only to find out they don't even have the witnesses anymore, and maybe he wins a dismissal because they don't have the proof to retry him. So in a way, it's just better all around for everybody. The state benefits, the family benefits, and certainly, he got an early stocking stuffer, because I'm telling you, 30 years for a murder is a gift, especially in California. You killed by firearm in this state, you are looking at a minimum of 40 to life, minimum.
Yeah, no doubt it was a good deal. But again, I think everyone wins. James Brenner, again, going to spend the next 30 years behind bars before he's even eligible for parole. Doesn't mean he's going to get it. He will be about 90 when that comes around. Exactly. So don't even know if he's going to last that long. All right, Philip, stand by. We'll take a break up next.
And that might be the lone reason why I consider this justice served. Again, James Brenner is 60 years of age. He's sentenced to 1 to 15 years for all 3 counts, plus credit for time served, of course. But each of those charges is going to run consecutively. So that's a total of what? 3 to 45 years that he'll serve. And it's going to be 30 years before he's eligible for parole. So in other words, by the time he turns 90, he'll be eligible for parole if he survives that long. Which, in my opinion, I don't think he will. So, yeah, justice served. Next up, there's going to be a plea hearing for Katrina Bauer, the mother of Elijah View. You remember Elijah, the 5-year-old that's still missing? Well, yeah. A plea hearing was scheduled for the mother of missing toddler Elijah View. Katrina Bauer's charged with child neglect, not for Elijah's disappearance, but for alleged mistreatment of Elijah and his 6-year-old sibling. A hearing was held where a plea hearing is scheduled for July 18. Bauer has not been charged directly in Elijah's disappearance. Her partner, Jesse Vang, has pled not guilty to child neglect charges. Investigators say Elijah was in Vang's care when he disappeared. At a preliminary hearing for Vang, earlier this year, detectives testified that Bauer brought Elijah to Vang's home on February 12, 2024 to help with behavioral issues through discipline and punishment. Let me remind you once again, guys. Let me go real quick. See if I can pull this up and if I can. Oh, there we go. 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 Elijah View is only 3 years old. 3 years old, still missing, and nobody's speaking up. Speaking of missing, I have some breaking missing persons news. This is an Amber Alert. Let me bring this screen to your attention real quick. All right, here we are. This is now. Keep in mind, this is breaking news. Okay. There's an Amber Alert for Terriana Mahomes, who's been missing out of Long Beach, California, ever since July 3rd, 2024. Terriana is 12 years of age, with black hair, brown eyes, standing at the time of her disappearance 4 feet 6 inches tall and weighs around 90 pounds. She was last seen wearing a white checkered shirt, jean shorts, and white tennis shoes. This Amber Alert has been activated by the California Highway Patrol on behalf of the Los Angeles Police Department. Terriana Mahomes was abducted from Long Beach on July 3rd at approximately 1540 hours. That's 3:40 in the afternoon. The suspect, if I can pull him up real quick, there he is, Clark Wheeler, 42 years of age, black hair, brown eyes, standing 5 feet 7 inches tall, weighing 140 pounds, with last seen wearing a black jacket, black shirt, and black pants. Both suspect and victim are believed to be on foot. If you have any information on the disappearance of Terriana Mahomes, the abduction of Terriana Mahomes, or the alleged abductor, Clark Wheeler, please do not hesitate. You're asked to call 911. Get in contact with the Los Angeles Police Department at 877-275-5273. 877-275-5273. If you can't get in contact with them, you can get in contact with the 24-hour call center for the National Center for Missing and Exploited Children. That number is 1-800-THE-LOST. 1-800-843-5678. You can also go through the FBI by reaching their 24-hour tip line. 1-800 FBI. 1-800-225-5324. Or you can remain anonymous by submitting your tips at tips.fbi.org. But whatever you do, please, 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 if you see something, say something. That way we can do something. We want to bring Terriana Mahomes home safe and sound, and we want to bring Clark Wheeler to justice. Now, moving onward from that piece of breaking news, we're going right to another case. This time, they want Young Thug's judge to be removed from the case. They're accusing the judge of misconduct, and the trial is being delayed yet again. Let's go to Julia Janae for more information.
To Georgia, where the long-running YSL RICO
have now filed motions seeking the recusal of Fulton County Superior Court Chief Judge Earl Glanville. This after he allegedly held a private meeting with prosecutors and their incarcerated witness, Kenneth Copeland, at which the defense was not present. At a hearing on Monday, Glanville said he would release the transcript of the meeting and allow another judge to decide whether or not he should remove himself from the case. This is the latest delay in the trial for Grammy-winning rapper Young Thug. His real name is Jeffrey Williams. He is charged in a sprawling RICO indictment along with 5 other co-defendants. Let's take a closer look at the details of this case and how we got here.
Ladies and gentlemen, Young Thug.
This is Atlanta rapper Jeffrey Lamar Williams, or as most know him as, Young Thug, performing on NBC's Saturday Night Live back in 2021. In the same year, his album, Punk, would end up on Complex and Rolling Stones' Best Album of the Year lists. The trap artist was innovating the hip-hop industry, collaborating with top artists, and getting a writing credit on Childish Gambino's song, This Is America.
And the Grammy goes to
This Is America.
But in 2022, police raided Williams' home, arresting him and setting off a 56-count RICO case against Young Thug, prominent rapper Gunna, and 26 other members of their music collective, YSL.
We are continuing our mission to target gangs, as we believe it is our #1 public safety deterrent crisis that we're in.
Prosecutors claim YSL stands for Young Slime Life, a criminal street gang associated with the Bloods. But artists within the collective refer to YSL as Young Stoner Life.
What they were doing is they were doing music, and they were posting things on social media or singing about things for the purpose of selling records.
The grand jury indictment characterizes YSL as a street gang and alleges 182 instances of the group participating in gang activity, including attempted armed robbery and murder, including the drive-by shooting of Donovan Thomas Jr. The prosecution believes Williams is at the top of the organization because of social media posts and song lyrics. After several legal battles, a judge ruled on the side of the prosecution that all of that evidence can come into the trial.
I'm in there up to the YSS school and that's why I'm the principal.
In terms of the Unabomber, somehow his manifesto was set to music with that have made it inadmissible. In other words, if you sing or rap your confession, you're aware that won't be admissible.
Many argue Williams' RICO case is just another instance of the legal system tying rappers to violent crimes expressed in their art. Williams addressed the issue on station Hot 97, asking for people to sign the Protect Black Art petition, saying, quote, "I always use music as a form of artistic expression, and I now see that black artists and rappers don't have that freedom."
They are targeting hip-hop, and the culture of hip-hop shows that they tell stories from the streets. So yes, some of the things that are said on those songs probably did happen. It doesn't mean that the person singing it did it.
Gave the lawyer close to $2 million, he had all the killings.
I think if you decide to admit your crimes over a beat, I'm gonna use it.
Over a year later, only 6 defendants remain in the YSL trial, with many of the members pleading guilty. Young Thug now faces 8 out of the 65 charges, and the trial is set to be the longest in Georgia history.
They claim that this is the most dangerous gang in Atlanta. When they decided to cooperate with the state, all of a sudden, they get probation, they get to go home and be free. So these people that took deals and are willing to testify against co-defendants have been free for 10 months and nothing has happened to them.
The jury in this case was already on a break until July 8th. They are now going to have to wait until a judge comes back with a decision on Judge Glanville's recusal. We'll keep to Georgia, where the long-running YS
and this case is getting crazier and crazier and crazier. Will the judge be recused? We'll just have to wait and find out how before the trial cranks back up again. Moving right along, an attorney says that the teen accused of killing her mother was threatened in jail. Now I wonder why that could be. I say maybe it's because of the fact that she's charged with killing her own mother. Anyway, in Brandon, Mississippi, a teenage girl accused of killing her mother and trying to kill her stepfather will remain in an adult detention facility despite safety concerns raised by her attorney. 15-year-old Carly Gregg charged with murder and attempted murder for allegedly shooting Ashley and Heath Smiley on March 19th in the family's home. Gregg allegedly shot her mother twice in the head and then invited a friend over to show her the body. He told police that he arrived home to find his wife on the floor and Gregg standing in the kitchen with a handgun. He was shot in the shoulder. Let's go right to the courtroom. Let's go right to Court TV.
All right. On the record, State of Mississippi versus Carly Madison Gregg, cause number 2024-34169. Who do I have here on behalf of the state?
Captain White Newman, Your Honor.
On behalf of the defense.
Bridget Todd, Your Honor.
All right. We have the only matters noticed for hearing today are document number 22, a motion for mental evaluation and McNaughton analysis. Document number 23, a motion for issuance of subpoena ducis tecum to youth court. Document number 24, a motion for issuance of subpoena ducis tecum to Blue Cross Blue Shield of Mississippi. And document number 28, a motion for issuance of subpoena ducis tecum to the Rankin County School District. Additionally, while we're here today, of course, going to conduct the Section 223A, subsection 11B, Juvenile Justice Act hearing that's required every 30 days. All right. This was the state's motion. We'll begin with the issuance for subpoenas ducis tecum. All right, let's begin with the document number 23, the motion for issuance of subpoena ducis tecum to the youth court. Is there any objection to that by the defense?
Your Honor, there is no objection to any of the subpoenas by the defense.
All the subpoena ducis tecum, correct?
All the subpoenas ducis tecum were finally being issued.
Do you have copies I can execute today?
I have orders on the school district and Blue Cross Blue Shield. The state would withdraw its motion with regards to the youth court.
All right. Give me the order. Show the second.
Yes, sir. I don't know if you need to give those more.
We'll give these to the court administrator and get a copy of them from the clerk's office, okay?
Thank you.
All right. State needs to give me an order withdrawing your motion for subpoena ducis tecum to the youth court, please, so we can keep MEC clean. All right? All right. Next matter on the docket is a motion for mental evaluation and McNaughton analysis. All right. Is there an objection to that by the defense?
No, Your Honor, there's not an objection. We just wanted to make sure that that would occur, the state's mental health evaluation would occur after Dr. Webb has finished his mental health evaluation, which should be finished in July.
I can't assure the defense of that. I don't know, so we're on a pretty tight time frame. Tight time frame here. This case is set for trial, I believe, in September, is that correct?
Yes, Your Honor.
When is Dr. Webb's report going to be finished?
He should be finished with his report by, I want to say not the 12th, but the Friday after the 12th.
Okay. Has the state already spoken? Looks like you spoke to Dr. Amanda Gugliano.
That's correct, Your Honor, and she's ready to proceed, assuming that our motion is granted as soon as possible, since we know that we have a trial date in September.
Okay. All right, so you have no objections other than the fact you want it to happen after Dr. Webb's analysis, correct?
Yes, Your Honor, and according to Rule 17 of Mississippi Rules of Criminal Procedure, that's technically the way that it should happen, is the state puts forward their mental health evaluation, or the defense puts forward their mental health evaluation, and then the state can proceed with the mental health evaluation 10 days after we have declared whether or not, our expert has declared whether or not Carly is competent or incompetent for trial. And as of right now, that can't happen. Yes. Your Honor, I'm not aware of that being in Rule 17. That's about discovery. Rule 12 is what talks about mental evaluations, and the state is not aware of anything in the rule which requires it to wait until after the defendant has completed its evaluation.
All right. Well, let's do this. If the only issue that we're in disagreement on is the timing of it, it's the state's motion. I'll let the state argue, then I'll let the defense argue, I'll let the state reply, I'll rule, and we'll be finished. All right? So, you step to the podium, step to the podium. Ms. Newman, and I'll hear what you got to say.
Your Honor, the state filed a motion for mental evaluation and McNaughton analysis on June the 17th of this year. Pursuant to the case law cited in that motion, as well as Rule 12, which governs mental evaluations in criminal matters, either party or the court on their own
can request that an evaluation be done if there's reasonable grounds to believe that such evaluation should take place. Pursuant to the defendant stating multiple times that they had hired a private evaluator, Dr. Mark Webb, to conduct an evaluation, the state believes that the insanity defense has not properly been alleged, but believe that upon information and belief based on their arguments regarding Dr. Webb, that that's what the defendant intends to introduce as some sort of insanity defense. The state is not required to sit back and wait for them to produce a report claiming that she's insane before funds can be acquired and evaluation can be started on behalf of the state. In fact, the case law talks about once doubt is raised as to someone's competence or insanity, the state bears the burden to prove that they are in fact competent and they are in fact sane. And so the state should not be required to rely on a report by Dr. Webb, who is a private evaluator paid by the defendant, before we are able to have the defendant evaluated. Specifically, we have gone ahead and contacted Dr. Amanda Gugliano, who is one of the psychologists who is certified to complete such evaluations through the Mississippi Department of Mental Health. As the court's aware, the way that the evaluations are conducted back in November of last year changed, and so there's two options for the state of Mississippi. We can go through the state hospital and have them assign someone, or we can go ahead and select someone and contract with them directly. We've chosen that option in order to streamline the mental evaluation. Our trial date is quickly coming upon us. There's nothing to require Dr. Webb to complete his evaluation by the date that counsel has stated in July. There's no guarantee that that will happen. Again, the state's not required to wait until he does that. They've offered no response to our motion. They filed no response. They provided no case law or cited to any statute or law that requires that we wait until after their evaluation is conducted. In fact, the state also, prior to coming to circuit court, tried to agree to a mental evaluation on behalf of the defendant. There was communications back and forth where the state said we would not wait indefinitely in order to have this done. We did not want to have, so to speak, them to drag their feet and say, well, we'll agree to it, but we'll sign it when we want to. I spoke with counsel, Mr. Kevin Camp. He's not in the courtroom today, but I feel certain that he would agree with me that I told him that we would have agreed to an evaluation. However, there was a deadline put on that so that this case would not sit unindicted and without a mental evaluation. Excuse me. Pursuant to our motion, we do ask that the defendant be evaluated both for competency to stand trial as well as a McNaughton analysis. Again, to streamline things, we prefer that it be done at the same time rather than one and then ordering that the other be done subsequent to that. We've asked that any medical, psychiatric, psychological, educational, addiction, or employment records and privilege be waived so that Dr. Gugliano can achieve her evaluation and she can get any records that are necessary, which is also why we filed our motions for subpoena ducis tecum that the defense did not object to in order to get her school records and Blue Cross Blue Shield medical and pharmaceutical records so that we know each and every provider that she saw. The state is again asking that our motion be granted and that we be allowed to use Dr. Gugliano to have this defendant evaluated as soon as possible rather than having to wait until after Dr. Mark Webb is complete with his analysis. Thank you, Your Honor.
Response by the defense.
Yes, Your Honor.
Your Honor, Rule 17.4 of the Mississippi Rules of Criminal Procedure states that if a defendant intends to introduce expert testimony relating to mental illness, defect, or other condition bearing upon the issue of whether the defendant had the mental state required for the offense charged, the defendant shall, within the time provided for filing pretrial motions or at such time as the court may direct, serve upon the prosecuting attorney, the clerk of court, notice of such intentions with the names and addresses of such expert witnesses upon which the defense intends to rely. The prosecuting attorney shall serve a notice on the defendant promptly, but in no event less than 10 days prior to trial, stating the names and addresses of any witnesses whom the state intends to rely upon relating to the issue of the defendant's mental condition at the time alleged. the way it's intended, and even the notes under that, talks about the defendant raises it, puts forth their expert opinion, then the prosecutor can rebut if it is found that the defendant has found that they're going to rely upon that. However, at this point, we don't know if we can rely upon that because our expert has not finished his mental health evaluation. Dr. Webb is very reliable, very good at his job, but it takes time. And in this situation, we had a child who is being charged as an adult, but who nonetheless is being kept in a solitary confinement 23 hours a day in an adult facility where he then goes to see her. And also, immediately after she was arrested and detained, she was placed on various medications, one being Abilify, which was an antipsychotic, by a nurse practitioner. So there have been medication issues too that Dr. Webb has had to wait to weigh and see what, if any, effects those were having on her. And that's just why it's taken a little time. But like I said, he is due to be done, and we are able to produce his mental health evaluation the Friday after July 12th. I'm not sure how long the state's expert will need or what testing will be involved, but that's well in advance of the September trial date.
Anything further?
No, Your Honor.
All right.
Your Honor, again, 17.4, sorry. Rule 17.4 comes into play once the defendant has filed a written notice. The defendant has not filed any type of written notice in front of this court. The state, however, has provided written notice that we intend to solicit the testimony of Dr. Amanda Gugliano, who is a certified psychologist who would do the testing on the defendant regarding any insanity and or competency. We believe at a minimum she should be able to get started on her competency evaluation with regards to this defendant. Again, there's been no written notice provided by the defendant to put Rule 17.4 into play. With regards to the medication that the defendant may or may not be on, again, if the defense attorney would look back, they would see that the state actually agreed to have her assessed by Region 8 in the beginning, and it was our intention that she be assessed by the Mississippi State Hospital at that point. However, the orders merely provided that she be assessed by Region 8 for evaluation and treatment. We've been asking since the beginning that she be evaluated, and we believe that it would be in both sides' best interest in order for judicial economy in this trial not to be continued if our evaluator would be able to proceed with her evaluation as soon as possible. Thank you, Your Honor.
All right. Court, having heard arguments from both sides, the court is not concerned with the particular written notice. The court's relying mostly on Ballard versus State of Oktibbeha County. The entire purpose of the notice requirement is to prevent trial by ambush for either side. Neither side should be surprised at trial. While I understand that the rule says not more than 10 days, it also says unless otherwise ordered by the court. Y'all are both on notice, y'all are otherwise ordered by this court. We're not going to wait until 10 days before the trial to release all of our information. All right, while the court would prefer for Dr. Webb's report to be complete, I believe this court's experience with mental evaluations is they're normally done in multi-stage on multiple dates. So for that reason, the court's going to grant the state's motion for mental evaluation and McDonald analysis. The court is not going to limit it until after the release of Dr. Webb's report. However, I do believe, from a practical matter, Ms. Gugliano is somewhat hamstrung until she gets Dr. Webb's report. If Dr. Webb's report comes back and says that, hey, there is no McNaughton issue here, we'll double back and we'll deal with that, okay? But what the court doesn't want to do is delay this case. As defense counsel said, she is, this court revoked her bail, and she is being held without bail. So I intend for this trial to go forward in September. All right, for those reasons, the court will grant the motion for mental evaluation. All right, now, as to the Section 223A, subsection 11B of the Juvenile Justice and Delinquency Prevention Act concerning juveniles charged as adults. All right, state of anything it wishes to add on the juvenile justice hearing?
No, sir, Your Honor.
Anything from the defense?
No, Your Honor. Other than there was an incident where an adult inmate who was being housed in the same pod area as Carly was making threats to harm and physically assault Carly, but Carly was able to tell her grandparents, who were able to tell me, and I was able to get someone from the detention center on the phone to handle it.
Mr. Chandler, is she being housed in the general population? You know?
She's isolated, sir.
She's isolated. All right. I don't tell the sheriff how to run his jail, but I believe our sheriff has enough good sense not to put this young lady out in general population at this point in time. Court looks at the following factors: age of the juvenile, she's 15 years old; physical and mental maturity of the juvenile. The court heard at previous hearings she's a very intelligent juvenile. Present mental state of the juvenile, including whether or not the juvenile represents a risk of self-harm. There was prior testimony regarding self-harm of this particular juvenile while she was not incarcerated. However, the court has heard of no such danger while she is incarcerated. Nature and circumstances of the alleged offense do not weigh in favor of the defendant. The juvenile's history of prior delinquent acts. I believe the state court doesn't have anything in front of it yet. The state's moved for a subpoena ducis tecum that may shed more light on that. You said you had information that she was...
Yes, sir, Your Honor. Upon information and belief, the defendant was brought some contraband, possibly a knife, to school and was sent to the Learning Center back in September of 2021.
All right. The relative ability of available adult and juvenile detention facilities. Court would know. I've worked all over the state of Mississippi. I think that the Rankin County Detention Center is jokingly referred to as the Hilton of jails throughout the state of Mississippi. Rankin County Sheriff's Department runs a very safe jail. For those reasons, the court will not have any change to the juvenile justice detention that she's currently maintained under. Anything further from the state?
None from the state, Your Honor.
Anything further from the defense?
No, Your Honor.
We'll be in recess. Best of luck to both sides.
And there you have it. The judge has ruled that she's going to stay in the adult detention facility, despite the safety concerns, and she will be tried as an adult. Well, you know the saying: don't do the crime unless you can do the time or pay the fine. This is a teenage girl who committed an adult crime. She's got to face the justice system for it. Next up, Kelly Matthews, a victim of convicted murderer Wade Wilson, recounts an incident in when he attacked her. Let's go to Julia Janae for that story.
To Florida, where one of the women who says that the convicted murderer, Wade Wilson, attacked her, is now speaking out. Last week, a jury recommended to a judge that Wilson be sentenced to death after the same jury convicted him of murdering two women, Christine Melton and Diane Ruiz. Those women were found dead back in 2019 after being strangled by Wilson. This is all according to the prosecution. Scripps News' Kate Coral spoke with a woman who claims that she was attacked by Wilson shortly before these murders took place. Take a listen.
Convicted Cape Coral murderer Wade Wilson will soon find out if he will go to prison for life or be put to death. I'm Fox 4 senior reporter Caitlin Knapp, and I dug into his background after the state attorney made an interesting comment to me about Wilson. The comment led me to track down Wilson's ex-girlfriend, who believes the murders could have been avoided if Palm Beach County deputies arrested Wilson for her reported crime.
We've heard from many women who have been victimized by the defendant, but maybe didn't go forward on charges or for whatever reason didn't find justice in the justice system.
That's what sparked the story after weeks of covering Wilson's trial and death penalty recommendation. Kelly Matthews dated Wilson and was interviewed by our West Palm Beach station shortly after he was named a person of interest in October 2019.
He kidnapped me and almost killed me.
And most recently, Matthews has been vocal on TikTok.
I dated this man. I don't want to be quiet about this.
Quiet about what she claims Wilson did to her in Palm Beach County. Matthews met Wilson in 2018 online, calling him charismatic and polite. She said things changed when he started reportedly using drugs.
It was just like a very toxic relationship, but he was never violent, ever.
Until February 18th, 2019, she claims. Matthews says Wilson agreed to go to a rehab in the Keys, but Matthews said that wasn't true, and they got into an argument.
And so I got back in the car and put my seatbelt on, and that's when he started choking me.
She says Wilson then cut off her clothes and eventually put her in the back of her car. Matthews says he sexually assaulted her, tied and gagged her.
At some point, he had bit my face.
She says he drove them to the Keys and Wilson got out and left. Matthews says she drove home.
I should have stopped at like a gas station or something, but I think I thought no one would believe me.
She and her mom called police. Matthews says she went to the hospital where they did a sexual assault kit and took photos of her injuries. In a police report I obtained from the Palm Beach County Sheriff's Office, it says they interviewed Wilson, who did not admit to any assault. The report says Matthews did have bruising on her neck and a cut to her lip, but they did not arrest Wilson.
He was like, no, this is hearsay. Like, you don't have any probable cause.
He, as in the detective who also put in the report, there are no witnesses to the alleged crime and no evidence to establish probable cause.
Do you feel like the system has failed you? Absolutely.
I reached out to the Palm Beach County Sheriff's Office asking why they did not arrest Wilson despite visible injuries.
I don't understand how someone can do something so severe to somebody else and not even get detained for it.
About 8 months later, Wilson was in Cape Coral and killed Christine Melton and Diane Ruiz. Matthews sees his conviction and death penalty recommendation as some sort of justice.
I feel like this is good for everyone that he's hurt.
Matthews says she wants to talk about what happened for her own sake and for other domestic violence cases.
I want people to know that they can leave, like get help.
As for Wilson, he's in jail, waiting to see if judge will agree to the jury's recommendation and sentence him to death.
We're a strong group of people that he didn't beat, and unfortunately it took 2 women dying for him to get noticed. You didn't win, and you're going to get what you deserve.
As of Monday evening, the Palm Beach County Sheriff's Office says that they are currently working on my request. Matthews says she wants to file a lawsuit against the Sheriff's Office for the outcome of her case. Again, Wilson will be sentenced on July 23rd, and I will be in that courtroom to bring you the decision. In studio, Caitlin Knapp, Fox 4.
Our thanks to Caitlin Knapp for that report. Such a difficult one. Let's bring back in Marie Pereira and Matthew Mangino. Matthew, something was missed here. Clearly, you never want to see a situation where someone may have been stopped before, but unfortunately, we've seen this before.
Yeah, I mean, every investigation is different. You're dealing with different police officers. You're dealing with different circumstances. It's hard, and especially in a domestic violence situation at times, to distinguish exactly, what had occurred there. But certainly this case, screams out for some intervention by the police, whether or not, there's some concern about exactly what the circumstances are. This is a vulnerable person who had obvious bruising, had a plausible story about how this occurred, felt threatened by the situation, and yet was left without any police intervention, was left without, any prosecution of her abuser. And, that certainly is a concern, and I'm sure that's something that's going to be reviewed to determine whether or not policies, procedures need to be updated or need to be amended.
Absolutely, it should be. And Marie, we heard her say that she was told, oh, it's hearsay, there's no witnesses. This is a domestic violence case. I know that's a part of your specialty. One of your focus areas is these domestic violence cases and victim support. I mean, just the process of going through a sexual assault kit can re-victimize people when they go through it. But she did all the steps that we tell people to do when they are in this situation. What needs to change?
I agree with Matt that this is going to be reviewed and heads will have to roll, because at the end of the day, the woman was attacked. She was allegedly attacked by him. She didn't go to the police at the scene of that crime, but she went, when she got home, she went to the hospital. They did a rape kit. She outcried to her mother, and she knew him. It wasn't plausible that it wasn't him. So they just went to ask him, did you do this? And he said no. And because of that, they said there's no probable cause. That makes no sense to me whatsoever. It was a sexual assault. He kidnapped her. He took her against her will, and whether or not they knew each other shouldn't have anything to do with it. Whether or not there was a slight delay in the reporting shouldn't have anything to do with it. And I think I'm glad that this reporter brought this out, because whoever investigated this and failed to even bring it to the DA to look at the case, to file a complaint, to bring it to the grand jury, is probable cause, not beyond a reasonable doubt. There was enough there for them to bring this man, at least on the minimal level, to some accounting for what he did. Somebody's going to have to pay for what happened here.
The woman in this story, she was not involved in this trial, but there was another person who was part of the indictment. She was assaulted by the defendant. She was his ex-girlfriend as well. He approached her first in this spree that he did. Let's go and listen to Melissa Montanez on the stand during this trial.
When you arrived at Mila's spa, did you see your Hellcat?
No.
Did you see a different car?
Yes. I went to the driver's side window. He wrote it down. I said, where are my keys? Where's my car? He was calm and just saying, get in the car, get in the car. And it escalated quickly.
Did you agree to get in the car?
No.
And when you would not agree to get in the car, how did he act?
Violent, aggressive, tried to pull me in the car physically, and I resisted, got plank style so that he could not grab me into the vehicle. I'm trying to reason with him, trying to talk to him, but there's nobody behind those eyes anymore. I was trying anything that I could to expand the amount of time that I didn't have to go to his car where I'd probably never be seen again.
The next step in this case for Wade Wilson, that jury already recommended death. There will be what's called a Spencer hearing in Florida for the judge to listen to any final arguments and then make a final decision. Matthew, do you expect anything less than death, even though there are some questions about the death penalty and how it is handled in Florida, especially when this jury did have to be they did not have to be unanimous, is my understanding, even though the law hadn't changed when this crime occurred.
Well, right, Julia, Florida, frankly, their death penalty procedure is maybe the worst in the country. Number one, you only have to have 8 out of 12 jurors vote for death in order to have a recommendation of a death sentence. That's the lowest threshold anywhere in the country by far. Okay, they've had problems with the fact that they let judges decide factual issues in death penalty cases. The Supreme Court struck that down, and there's definitely a basis to challenge any death penalty. Certainly one in which there's a 9-3 for the death penalty or a 10-2. This case is going to be reviewed by the Supreme Court, and one of these cases out of Florida might be the final case where the Supreme Court says you need to have unanimous jury verdicts for death. It doesn't exist right now, and Florida has the worst policy in the country.
Certainly under review by higher courts, and prosecutors are concerned about what the outcome will be.
and we will see what becomes of this case. Whether Wade Wilson will do life in prison or will he be sentenced to death. In the meantime, I gotta agree with the fact that that police should have gotten Wade Wilson sooner when Kelly Matthews was attacked. Unfortunately, that wasn't the case, and had they got him sooner, this would have been a whole different story. Next up, a missing child found, but an arrest of the parents. Yes, the son of a missing NFL player has been found safe. But the NFL player father and mother have been arrested according to Indiana State Police. Here's the breakdown. Missing 14-year-old Bryson Muir, son of former NFL player Daniel Muir, has been located safe and his parents are in custody. In a press release, ISP and SWAT executed search and arrest warrants on Wednesday morning at the Logansport home of Daniel and Kristen Muir. Bryson, who appeared safe and well, was released to the care and custody of the Cass County Department of Child Services, according to ISP. Authorities said Daniel and Kristen were arrested on charges of obstruction of justice. Daniel is additionally charged with domestic battery. A silver alert was issued from Bryson, who had last been seen leaving his grandmother's home in Ohio with mother Kristen in a white 2015 Chevy Suburban belonging to Servant Leaders Foundation in Kokomo. Father Daniel is a former Indianapolis Colts defensive tackle. Wright said Bryant showed up to her home with a black eye and swollen face. After he and his mom left Wright's home, authorities said Wright called the police, with concerns. Shortly after leaving the house, ISP said the vehicle Kristen was driving was pulled over by the Garfield Heights Police Department in Ohio, but Bryson was not in the car. According to ISP, Daniel and Kristen Muir agreed to bring Bryson to meet with ISP investigators at the Peru Post on June 21st. The agreement was to meet at 12 noon. At approximately 11 a.m., police said the Muirs backed out of the arrangement. All I can say is I'm glad that young man is found safe and in good hands of people that are actually gonna care for him until he can be put with a family that will care for him. So Thursday we had off for the 4th of July, but we got a new trial coming up. This was reported just yesterday. A Michigan man is standing trial on murder charges in the death of community leader found dead outside of her home. Michael Jackson Bolanos. Yes, you heard the name right. Michael Jackson Bolanos faces a potential sentence of life in prison if convicted of the first-degree murder and premeditated murder of Samantha Wall, who was killed on October 21st, 2023. Wall was the president of the Isaac Agree downtown Detroit synagogue. She was found dead outside of her Detroit home after she was stabbed multiple times. At the time of Jackson Bolanos' arrest, police said there was no indication that the murder was the result of a hate crime. Investigators say they believe Wall was randomly targeted while the defendant was trying to break into vehicles. During a police investigation, Jackson Bolanos told officers he had nothing to do with Wall's murder. He took the stand in his defense during the trial, admitting that he lied to his girlfriend on October 21st when he told her that he was going for a walk, when he was really planning to steal from unlocked vehicles. Jackson Milano said while he was doing that, he saw a dark figure lying outside, which he later realized was a dead body. Quote, I was over there, going into motor vehicles, and I felt like I had to call the police. I felt like if I had to call the police, I'd be incriminating myself. That's what he said when he testified. Jackson Milano's defense has tried to suggest that Wall's ex-boyfriend may have been behind the brutal murder. That ex allegedly confessed to the killing before, later saying his memory had been altered by the use of drugs, including antidepressants, nerve treatments, and cannabis. Prosecutors previously said they found no proof to indicate that the ex-boyfriend was involved. Testimony will resume on Monday, July 8th. If this ends in a guilty verdict, Michael Jackson Bolanos is facing life in prison. Let's see what'll happen. And finally, in the latest chapter of Did He Do It? Vibe magazine is named in a new lawsuit accusing Sean Diddy Combs of sex trafficking, which is why I said it like I said. It's the latest story in the case of Did He Do It? The latest lawsuit filed against music mogul Sean Diddy Combs not only accuses him of sex trafficking and drugging women, but accuses a popular publication of conspiring with him. The filing on July 3rd marks the 10th lawsuit implicating Combs. On November 16, 2023, Combs' former girlfriend, Cassie, filed a lawsuit alleging rape and abuse. The lawsuit was settled a day later, but what followed was a slew of other lawsuits from men and women claiming that they had been abused and sex trafficked at the hands of the entertainer. The newest filing contains accusations from a woman who worked as an actor in the adult film industry in California as a teenager before moving to New York in 2004. While the filing does contain her name, Court TV shields the name of the alleged victims of sexual violence wherever possible. The plaintiff said that she met Combs in 2004 when she joined her boyfriend, who was attending an audition to be part of a campaign for Combs' Sean John clothing line. The lawsuit alleges that as a deal to get her boyfriend cast as a model, the plaintiff was told she would need to work at Combs' white parties. Combs parties in both the Hamptons and Miami, Florida. Dubbed white parties were known as lavish events where guests only donned white attire. According to the lawsuit, when the plaintiff attended the first party, she was given clothing she was told to wear as a uniform. A photo of her wearing the outfit was published in the November 2006 issue of Vibe magazine. But the plaintiff said she had no knowledge that the photo was taken, nor did she give permission for it to be published. Because she believed the parties to be a legitimate employment opportunity, the plaintiff agreed to return to Combs' parties in the years following. But around the third white party, defendants Tamiko Thomas and Sean Combs demanded the plaintiff begin engaging in I won't repeat it, but it is because it's rather graphic. With guests, as they learned about her past in adult entertainment and used it forcefully to coerce the defendant into sex work. Tamiko Thomas, a named defendant in the lawsuit, is described as a kind of assistant to Combs in the lawsuit. Defendant Thomas was to defendant Combs as Ghislaine Maxwell was to Jeffrey Epstein. That's what I call comparing and contrasting. The lawsuit claims there's evidence of the alleged sexual assaults because of hidden cameras inside every room at Combs properties in both New York and Florida. The filing says that the videos are either still in Combs' possession or may have been seized by the FBI when they raided the rapper's properties in April 2024. While the alleged behaviors detailed in the lawsuit are similar to others Combs is facing, this filing takes an additional step of alleging RICO crimes by Combs as well as by a magazine and its parent company, Penske Media, or PMC. The plaintiff points to Combs' long-standing relationship with the publication dating back to 1993 and argues that the magazine's general business partnership and financial support, as well as marketing and coverage of the white parties, made them party to the alleged actions. Defendant Vibe and PMC intentionally mislabeled plaintiff as a guest at the white party in its magazine to further conceal the true intentions of the event and plaintiff's employment role at the event in an effort to further the goals of the defendant's illegal and criminal enterprise. The lawsuit notes that the November 2006 issue of Vibe contained 18 pages linked to Combs or his businesses, including a cologne line called Unforgivable. The tagline for Unforgivable cologne was, "Life without passion is unforgivable." Who knew defendant Combs' true passion was being the head of a corrupt organization that abused women and trafficked sex and narcotics? Court TV reached out to representatives for Combs, Vibe, and PMC for comment. Combs has previously denied accusations in other lawsuits, calling them false, offensive, or salacious. So, guys, you be the judge. Did he do it? Did Vibe magazine have a hand in it? I guess we'll have to answer that question when, if and when this thing goes to trial. Alright, I'm about to wrap this thing up on a shortened edition of Bethea'S Byte Reloaded. But before I do that, I'm going to go ahead and bring Julie Grant back as she gives contrast to the Karen Reed case with the alleged suicide of Sandra Birchmore. The question she's basically asked, how and why did Sandra Birchmore die? Alright, so once more, hang on tight because it's time for Julie's opening statement on
opening statement. What happened to Sandra Birchmore? Was she murdered? Her death in 2021 was ruled a suicide. She died at her apartment in Canton, Massachusetts, that same area that's been scrutinized with the trial of defendant Karen Reed. And while I still think that the Karen Reed trial has brought out the worst in people, the hate and the vitriol being spewed was reprehensible. But if there was something good that came out of what I call that debacle in Dedham, it's renewed interest in the mysterious death of 23-year-old Sandra Birchmore. She was reportedly thrilled to become a mother. She was pregnant at the time of her death. That was ruled a suicide. And it was something that puzzled many people at the time and still does. Because why would someone who loves her life and her unborn baby so much kill herself? Well, according to the Boston Globe, who's done outstanding reporting on this case, Birchmore's family hired renowned forensic pathologist Dr. Michael Bodden. And he says this was a homicide. Strangulation is what he says occurred here. So who would want her dead? Well, the Globe reports that 3 Stoughton police officers resigned after an internal affairs investigation took place regarding allegedly sexually abusing Birchmore when she was a minor and enrolled in the department's Explorers program, a program for kids who want to learn about what police do. Now, if Sandra Birchmore was abused as a child, and if she was murdered to cover it up, If that happened, I don't know if it did, but I'm just saying, if those crimes occurred and she was victimized in those horrible ways, the person or persons responsible must pay the price. They must be prosecuted to the fullest extent of the law. Children deserve to be protected. Predators deserve to be punished in the worst way.
I couldn't agree any further than that. She said a whole mouthful and said everything that needed to be said. Those three cops doing if they did Sandra Birchmore like that, they deserve every bit of punishment that's coming to them. And I only hope and pray this case gets solved and the family of Sandra Birchmore will get the answers they're seeking and the justice that comes with it. That's how I wrap things up on this sizzling Saturday night. Bethea'S Byte Reloaded Saturday night main event. I want to thank everybody for joining me. Thank you for your commentary, your all the support you've given. So this is just to give you a mindset of where we are. This is the free way to keep supporting Bethea'S Byte Reloaded. Be sure to like, share, subscribe, comment. That's the free way we do it. If you're looking to support financially, I wouldn't mind that either. That helps out. That helps out greatly. You can tip me through Cash App. $EKB316. You can drop it at PayPal, EKB316, or Venmo, EB, The Last Outlaw. Nothing obligated, but it's always appreciated. As far as how to get in contact with me, I'm all over the place, guys. You can hit me up on Facebook at Bethea'S Byte Reloaded. On X, EKB316, all caps. Here on YouTube, at Bethea'S Byte Reloaded. Instagram, EKB316, that's lowercase this time around. On TikTok, where I'll have a link to this edition in my bio, you can check that out at King of Hearts 316 2021 over on TikTok, or you can email me. My address has not changed. KingofHearts316_09 at outlook.com. Alright, so there you go. That's how you can get in contact with me. Hey, so to wrap this all up, here's a slogan, guys. This is the home for true crime news without the drama, unless it's in the courtroom. This is where your opinion matters, where lively debates are encouraged, your voice is heard, and above all else, above everything, justice is served. Alright, so now you know where you are. This is Bethea'S Byte, and it's reloaded. I'm Ernest Bethea, the Last Outlaw. Thank you all so much. Let's do this again come next weekend. Until then, you all know what to do. Bite this. Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe, and drop me a comment on this video. And be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.